May I, my lord?
Yes.
I beg to mention item number 3, my lord.
3.
This matter will be listed on 5th of December, my lord. I have taken consent from the respondent.
Why?
Sir, report call for my lordship.
What report?
Service report, sir.
Service report.
Yes, my lord.
When did you take the step?
No, my lordship. Report from the department, my lord.
What report? Let us see the file.
And we have received the reports and we have to go through the reports properly.
This is regarding dismissal.
Service matter, my lordship.
Which, that's what I'm saying. Is it dismissed from service? Dismissal from service.
Yes, my lord. Increment was.
One increment.
Okay, okay.
Who is your for the petition? No,
Yes,
respondent.
State.
State.
Yeah.
Who is for the respondent?
By which order the report has been called for? What report? It's a writ appeal. There's nothing. Anyone puts it on.
You want to produce the original
Records or report?
Records, my lord.
Ah,
okay, okay.
Records.
Okay.
Okay, fine.
Had MS K. Wangma, Learned Counsel for the appellant. State, Learned State Counsel appearing for the appellant. You are for?
The respondent, my lord.
And Mr. L. Perme, Learned Counsel for respondent, private respondent.
Private respondent.
Only sole respondent. Sole respondent. MSK Wangmo, Learned Counsel for the Learned State Counsel submits that she is yet to receive the
We have
records.
received the records.
She has received the records, but she needs some time to go through the records and place before this court, for which she seeks for 1 week,
No, my lordship. 5th of December.
2 weeks time.
My lord, I pray for peak statement.
Huh?
For peak statement.
Okay, we'll fix it on 5th. Praise the Lord. List this matter on 5/12/2023.
Oh, bless.
Has it been admitted? No.
This is the issue. This is the issue.
Okay. I think
May I, Your Lordship?
yes.
Your Lordship, we have just filed our affidavit in reply this morning.
Which one?
Affidavit in reply.
Item 1.
Item number 1.
Okay. What do you want?
Well, we have just filed our affidavit in reply this morning.
Reply.
Yes.
Rejoinder.
Yes, rejoinder affidavit.
We would like to know the status. Solid Waste Management.
Yes.
Can you obtain the status?
So we have filed additional
It's a-
affidavit also. You have-
Saying what?
Saying that
Saying nothing.
saying that, no, we are implementing the.
No, just saying implementing will not be enough. That's the reason why we want to see the status.
Your additional affidavit is of 24/8/22.
Lordship.
You had notified, you had made 3 rules, regulations.
Yes.
Those have not been yet published, I suppose, in the Gazette. So without that, how will you act on this? This is an important aspect. So why don't you get a status report on all these aspects and place it before the court? That's what my lord wants.
Yes, sir.
Because just by saying that we are doing this, we are not doing, but your main thing is that those rules or bylaws that are there, regulations that you have framed,
Yes.
put up for public objections or something, those have not yet seen the light of the day. It should be published. So kindly
Has
have
it
a-
been published?
No, there is no indication to that.
So far,
Page 40.
to that effect, Lord, or that may be passed. Okay.
Page 40.
Page 40 of the additional affidavit.
No, no, no. The affidavit. Because that, there is an order of this court also for preparation of that. You prepared, but not notified. Page 40, you can come to your first affidavit. The first one of the solid waste, bylaws 2021. There is an order of the court. Complete with all the photos.
MS, your name please,
Oh, si, bonjour.
C so and so, appearing for petitioner. And also her MSGA, learned additional senior government for the state. Miss MS so and so submitted. She has filed her affidavit in reply this morning. We next para. Huh? We find that the additional affidavit by the state authorities has been filed in the year
August 2022.
in the month of August 2022. Without indicating whether the rules, bylaws, draft notifications, or / rules / bylaws has been published in the official gazette. We also take note that the status, the implementation of the solid waste management has been taken as per the provisions of law. In view of the above, the learned counsel for the respondents. You also?
Yes.
You are the main party.
Yes, I'm not a necessary party itself.
Why?
But this is purely for municipal.
Okay.
Not for-
The learned, the MSG at the learned state council shall place the stated reports on the next date fixed. Is this matter? When can you?
After 3 weeks.
After 3 weeks. That's right.
But you take a comprehensive view on everything.
Plus. Like.
May I play this?
Not before this court.
Yeah,
Huh?
yes.
Is it?
Yes, my lord, because
That law is well settled. It cannot be some person's liking. Whether it should be place A or place B. High Court judgment, our High Court judgment, and the Supreme Court.
my lord,
Prasanta Deka.
Justice.
but in this case, my lord, in any case, although the
Anyway,
Yeah.
Again. List this matter before any other appropriate bench, whatever one of us, put in bracket, me.
Apply.
May Lordship, Lordship,
This is
Lordship, this matter may be list after Lordship.
MSG at the. It's the same thing which you have discussed with me. When I was, when this court was
Digital.
the other side.
Lordship, this is service matter, Lordship.
I know,
Yes, Lordship.
the regulation of work charge employee.
Yes, Lordship.
That's
Casual.
right.
Yes,
The work
Lordship.
charge
Power.
Actual power department.
Lordship, my senior Lordship, after leave that Lordship.
Anyway, I cannot take up this.
Yes, Lordship.
Though I have not appeared, but then there was a dispute.
But you have already passed an order in compliance with the. This order is already- There is already an order passed by the authorities in pursuance to the order of the court. Now, whether contempt, deliberate violation would be made of, you just have looked in that respect. My lord cannot take up, my lord will not take up.
Not in
My
this
lord,
matter, in
not in
different matter.
different-
That was discussion of.
It's okay.
Then
It's a related, not
this
related.
is Department of Power.
It was Department of Hydropower Development.
But something
Same thing.
we have discussed with all those for entire state, for entire department.
True.
Anyway,
Department.
list this matter before any other appropriate bench without one of us.
Look into that also. Whether this would be required to you also, please go through that. Your affidavit, page 6 and 7.
Much older.
Made with Lordship.
Yes.
And now this read appeal is directed against the judgment and order dated 28/1/2022, passed by the learned single judge, wherein my lord, the order of removal of the writ petitioner was interfered with.
Ready? Are you ready? Yeah. Yes.
But the learned single judge interfered with the order of removal from service on 4 grounds. First was violation of the principles of natural justice on the ground that, my lord, the documents, all documents were not furnished to the writ petitioner. That I will argue, my lord, there was no pleadings of any prejudice that was caused to him. Second ground was that the inquiry officer was junior to the petitioner, and as such, his personal biasness against the writ petitioner. That was not even pleaded, my lord. Captain Paul Anthony was relied upon.
Relief granted beyond pleadings.
Yes. Captain Paul Anthony was relied upon, rightly or wrongly, but there was no material on record to even show how this the criminal proceedings and the departmental proceedings were similar. Because
That too, after he had filed his written statement. And he had filed his written statement, he has disclosed his defense statement.
yes,
Then
the thing is, this is not a case. He has not even denied the charges. He in fact has made some excuses actually.
clarified.
And the last ground also that the disciplinary authority was a part of the appellate proceedings, that was also not pleaded.
What is the positive fact that he was part of the appellate?
No, my lord.
No, why don't you take us in seriatim, right from the charge sheet?
My lord.
Sure, memorandum, sorry.
Well, but I am passing on a list of days for Lordship convenience. If your Lordship may kindly have page 38, that is the memorandum of charges. Annexure 4.
Yes.
My lord, I will take your Lordship directly to the imputation of charges at page 39. There were 6 charges. Charge 1, may I read? On 2012-2008, one SBI check for rupees 30,000 was deposited by one customer, Mr. Mingo Basar, to his CA AC number 98. The official paid the amount of rupees 30,000 even before it was collected. The check was returned unpaid, and Sri Basar deposited rupees 20,000 during the official's tenure as branch manager to refund the amount. Instead of depositing the amount in the customer's current account number 98, the official kept rupees 12,500 in the branch vault, and the balance amount of rupees 7,500 was taken by him, and he refunded rupees 7,500 only on 6/1/2009 in the linked branch account of SBI Basar. Is the first charge. Second charge is on 23/12/2008, the official debited a sum of rupees 1.5000 from the branch sundry deposit account. Out of this, he credited his SB account number 04 with a sum of rupees 70,000 and credited the remaining amount of rupees 45,000 in SBAC account number such and such of Mrs. such and such. On the same day, the official withdrew rupees 70,000 from his SBAC number 04, where there was no balance, thus creating overdraft in SB account number such and such of such and such. Mrs. such and such also withdrew rupees 45,000 from her account on 23/12/2008, which credit vouchers were prepared and posted by the official with this sum of rupees such and such. He purchased a Maruti van belonging to her. The official unauthorizedly debited branch suspense account. Suspense account is, these are like kept for contingencies. A sum of rupees 40,500 on 24/12/2008 being salary of 3 employees. He then withdrew rupees 10,000 on 24/12/2008 and rupees 5,000 on 30/12/2008 from his SBAC account number 04 and prepared a credit voucher of rupees 15,000 and credited the amount in his SB account on 24/12/2008. This was deliberately done even though he was advised by the head office that his salary for the month of December was only rupees such and such. So the official withdrew an excess amount of rupees such and such from his SB account, which is in contravention of bank rules and procedures. Number 4. On 26/12/2008, the official took rupees 1,30,000 from Sri B. Payam, branch manager of APRB Along, under false pretenses. Since the official did not submit the required check the next day, Along branch debited APRB link branch account on such and such for the sum of rupees such and such. 5. On 30/12/2008, the official falsely informed head office that Basar branch immediately required rupees such and such. The amount was withdrawn by the official from SBI Basar branch, and out of this amount, he deposited rupees 2 lakhs in the branch, and the remaining 8 lakhs were kept by him. On such and such, he deposited rupees 7,74,000. The shortfall amount of 20,000 was made up by him unauthorizedly, debiting the account of one customer, Mrs. N. Bam, having account number such and such. And again on 6/1/2009, an amount of rupees 7,50,000 was unauthorizedly taken by the official from the vault against the withdrawal slip of 7 from his SB account number, which was thus illegally overdrawn. Charge number 6. By indulging in such above acts, such and such has willfully caused serious loss of reputation to the bank, and the said acts also resulted in huge financial loss to the bank. The official has also acted with total disregard to the position of trust and responsibility to which the assignment of branch manager post entails. So these are the charges, Your Lordships. Serious charges of financial mismanagement. He has been using the bank's money for his own benefit. The reply, Your Lordship, will file at page 41. The Lordship's got the 41. Page 41.
This
40?
41 is the reply.
Is the statement
So, sorry, man. Sorry.
45.
Page 45. 41 minus same imputation of charge, same thing. Man. Page 45 also.
When was he promoted as branch manager? Any idea?
That level, he must have been promoted much earlier. He's a very, very senior officer. He's retired now.
Then
Page 45. Yes, it's my note body. Justice.
the initial inquiry was, punishment was interfered with by the
Yes.
court. And it was remanded back from the
Remanded back,
inquiry
yes,
stage.
again interfered.
And the second inquiry, where is the inquiry report?
Inquiry.
Page 69. No.
Page 94. It starts from 90.
They
94.
were 93 to 106.
Yes.
I'd like to read the reply first, my lord, the reply to the supposed article. Read, my lord.
One clarification. 4 charges. 6 charges. sorry.
Six charges.
5 proved, 1 partially proved by the inquiry. The disciplinary authority said that he is holding all the 650 proofs. Was this communicated to you along with the inquiry report? With the disagreement
I'm just going one line before the query. Inquiry concluded. I was not given the inquiry report. Fine. It was given to the disciplinary authority. Disciplinary application of mine submitted this one to me.
Okay, that was
Yeah.
submitted along
Yeah.
with it.
I challenged this one because inquiry report was not given to me by the inquiry.
Which
It may
one?
not be.
Page 94.
Yes,
It may not be.
Page 94.
page is that.
Inquiry report.
Inquiry.
You have,
This is not-
you have challenged the inquiry report.
In fact, this is not inquiry report. This is the finding of the disciplinary authority on the inquiry report.
Disciplinary proceedings was forwarded to the petitioner by communication dated 1/5/2018,
So
page 107.
disciplinary authority communicated me the inquiry report along with his findings. This is under annexure. What my learned friend is referring to this annexure. It starts from page 93. This is not the inquiry report. This is a communication from the disciplinary authority, giving his views on the inquiry report. Fine.
And it was communicated to you along with the inquiry report.
And so was
This is,
issued to him.
this is all along, this is the inquiry report. You also kindly see the findings of the disciplinary authority on the inquiry report.
Brother is saying that better things were given to them. They have done
No,
better.
no,
things.
no, I am prejudiced.
Which gives,
I'm-
which
no, I'm
gives you
prejudiced
more
because-
avenues.
Then I'm clarifying, this is a question of academic now. If inquiry officer given me the report, I would have a chance to give a representation with regard to the inquiry.
That's right.
For a
That's why-
disciplinary authority,
That's why I was
who is
asking.
also the appellate authority.
That's why I was asking, it was not given to you. Inquiry report.
Inquiry report must be given to me. What was given
It
to
was incorporated in the findings
It
of
was
the
given the
disciplinary
finding of the
authority.
disciplinary authority. There are two different things. One is inquiry report, another is finding of the.
And
disciplinary
thereafter, Sopos was issued, he replied to that.
authority.
No, you're that view, maybe correct me if I'm wrong. There is no law which says that the inquiry officer has to give the report directly to the delegate. No, the inquiry officer submits the report to the disciplinary
Yes.
authority. Then the disciplinary authority will give it to you. Now, here, the disciplinary authority, subject to correction, was varying in one charge with the inquiry officer's view. So maybe they have resorted to this method. Now, had you objected to this in your representation against this?
This which I have challenged in the read petition.
Forget it.
Yes, no.
When this, after this, sorry, we are digressing, just
No,
to
no,
get into
this
the
is
progress.
recording now. We have to.
These are technical things. You got this, page 94.
Yeah.
You submitted a representation against this. Did you take an objection that this should not have been the mode to submit, give me the inquiry report? Yeah.
In fact, they are also admits almost everything.
Then they imposed the penalty. Penalty was removal with some recoveries.
Yes.
With some recoveries, 6 lakhs or something recoveries. Now, then you submitted an appeal. The appeal then should go to the board or to the chairman.
No,
Who considered the
It should go to the board. Board is the.
If the
appellate
disciplinary authority is the chairman, then it has to go to the
So
board.
the board has considered
Yes.
the appeal.
authority. Yes. And while considering the appeal, the disciplinary authority took part in the proceeding. He took the vital role in the disciplinary.
So that
is
again
not-
would be a debatable issue. There are
That
decisions.
that is how I have.
Because he participated therein as one of the members of the board.
No, yeah, member of God, but that should not be. But I am submitting what the law requires. A person who was imposed penalty, he cannot be part of the appellate authority.
There is one judgment of the Supreme Court which says that inquiry officer cannot be the disciplinary authority cannot be a appellate.
Appellate.
But
No, if there is a decision, even if that authority is a part of, if he has not participated in the proceeding, then it will not affect the delinquent.
we'll have to see what prejudice has
Yeah,
been
yeah.
caused.
That,
That you will have to show. Please continue.
In
Sorry.
fact, I will show, my lord, that is not even a pleaded case.
You continue in your own place.
Page 45 is the reply. I am showing this because he is not denied it, he is making excuses. Page 45 is the reply.
Let's not put it as excuses. He is trying to give clarification.
Clarification, I am sorry. Page 45.
no, I'm
Be comfortable.
I'm participating.
No, we're hearing. Hearing. We have got our clarifications. We'll go slowly, one by one. Yeah, yes. Okay, this is the reply we got it. Now proceed further. So you say that there is no denial.
No denial.
No denial.
He
And
clarifies something.
He has clarified.
There is a page 45 onwards. He says Migo Barsa is a highly reputed man, so in good faith I did all this and all that. Chart 6, he says because there was some threat to him, that's why he had to do it.
Then what happened?
Then I will not bother your lordships with the documents because that was interfered with initially. Then after this, on 8/2/2010, inquiry report was submitted by the inquiry officer. On 10/12/2010, order removal of the respondent or petitioner from service in terms of order rule 38B4, Roman 4 of 2001, along with the fine of rupees such and such, was imposed on him. Appeal was filed, that was rejected. Review application also rejected. Then thereafter, he filed the writ petition being WPC 206 AP 2012. That was allowed by judgment and order dated 21/4/2007, giving liberty to the appellant bank to pursue
Press.
again. Yes, press inquiry. Then your lordship will have
Stage of inquiry.
from the state of the inquiry.
Can come to 95 day inquiry.
Yes. Then inquiry officer, everything, presenting officer, everything was issued, and notice, everything was issued. Your lordship will find the department board proceedings records from page 78 onwards.
These are the department proceeding inquiry.
Yes. Day-to-day proceeding records. There were three witnesses on behalf of the bank. He cross-examined one, records will reveal, he refused to cross-examine the other two. He participated here.
Now, did he raise any objection with regard to the inquiry officer during the?
No. It is not there in the pleadings also, I will show it from the pleadings.
Readings in the petition.
Up to page 92 is the day-to-day proceeding record.
Yes.
Then the disciplinary proceeding findings, your lordship will find at page 93. Then page 107 is the forwarding of the whole set of department proceeding records to the petitioner.
You have the inquiry officer's findings.
Yes.
Along with the.
Yes. Findings of disciplinary proceedings. As your lordship pointed out, one charge he did not agree to the result. This was forwarded by memo dated 1/5/2018 at page 107.
Fine, let's just go through that.
No. Shall I read, madam? Then.
Now come to charge number 3.
Madam.
Page 19.
Yes, madam. Yes.
So you have in the third
I have-
column,
Yes.
the inquiry officer's finding. Right?
Yes.
Now come to page 100.
Madam.
The last column,
Yes.
not agree with the inquiry officer that charge is partially proved.
Yeah.
Now, where is the finding of the disciplinary authority to the same? Why he is disagreeing?
This is the only part, this remark.
There has to be a finding. That why he is saying that this is not partially proved, but it is proven. That would be a disagreement.
That,
Merely writing.
yeah,
this will not-
that is there.
Is there anything in the record to this effect why he is disagreeing?
Records I have brought, but
But he can't merely say.
yeah,
"I
of
agree."
course, that is there.
1988 should be clear.
वो ये नहीं बोल रहा, वो ये बोल रहा है। ऐसा सिर्फ लिखने से नहीं होगा।
Is it the one of the ground you have taken?
I have taken this ground
findings of
anyway, that there was no disagreement note.
Yes.
That article of charge number 4 was not 3 was not proved.
No,
Then you're not going to. Okay, proceed. So all the charges were done.
yes.
Then what happened?
Then this was forwarded by this memo at page 107.
What is his reply? 108.
Same thing, your lordship.
No. Has he taken any technical plea here?
No, my lord.
Sure.
Page 108.
I'm ready.
Nothing is.
108.
My lord has already read it.
Yeah.
There is nothing.
There's nothing.
Then
Same
what
thing as in the reply.
Then what happened?
Yes.
So
Then
penalty
thereafter,
is-
show cause notice was also issued. He replied to that also.
Hmm.
Then ultimately.
Of the record, it happens unless they engage a lawyer.
But we'll have to go to the wholesome view.
Yeah.
Okay, then what happened?
Then this punishment order removal at page 120 onwards was issued, 120 to 123. 122 would be the relevant
Okay.
removal from service with immediate effect. Page 122 euros, number 4. Fine of interest amount of fraud about rupees such and such. Some.
So you had two chances to reply.
Yes.
One with against the inquiry report finding and then against with regard to the penalty.
Hmm.
So, reports of proceeding is at of stages.
Ample opportunity.
So, but you never took technical plea on that. Anyway,
These are the
then what
benefits,
happened?
mandatory-
Then what happened, Mr. Paring? What happened?
124, they file an appeal.
120, 123 is the impugned order.
Yes.
Penalty order.
Penalty. 124 is the appeal. It's up to page 134.
Okay, come to the judgment.
Judgment.
What's wrong in the impugned judgment?
And I may also point out from the writ petition, there's no pleadings to the effect that the inquiry officer was junior to me who was promoted. And there is no pleading to the effect that the disciplinary authority was part of the appellate proceedings.
Where it is,
It must, I have checked out records, my learned friend appeared in the writ proceedings. Written argument was filed.
but
It
he
must-
has considered in, you have considered in the writ proceedings,
Considered to what, Your Lordship?
in the writ petition, you just come to
Para 22, 173.
paragraph 25. 175. Also not controverted the above submission of Mr. So-and-so, so-and-so. Is it a particular point or all the thing?
Also, submit initiation of Binovo inquiry is bad. when the inquiry report was not been furnished to the petitioner and he was not allowed to cross-examine the witnesses, and the inquiry report was not. But this is beyond the pleadings, man.
But then you have considered.
I'm not exactly sure what has been considered here.
No, you come to page 21, para 21, page 173. Come to para 21, 173.
Yes, doctor.
Here the statement of Mr. Bull was that the appeal was not disposed, was dismissed by a non-speaking order. So and so, disciplinary authority is not a party in the appellate forum. But he also played a vital role of disposal of the appeal, which is bad in eyes of law held by so and so. Now, para 22.
That is why I'm saying.
No, para 22.
Yeah.
The limp of submission of so and so learned counsel for the petitioner is not disputed by G. Sarak, learned counsel for the petitioner, while dealing with the issue in so and so, so and so, so and so. So, fine, there was nothing. He took it up as a legal argument, but you have considered to that.
No, this is particular, this para 22.
21.
Para 24 also.
24 also, you see.
But this is my humble submission. I am not privy to what happened there and how this has been recorded.
But you are, this is the,
But
this
I-
is the impugn judgment.
Yes,
order.
but
You are
I rely
to
on the
challenge.
records, my lord. Records of the writ
We'll
petition.
see, but we'll have to
Yeah.
cross this,
That is there.
cross this hurdles. What is read para 24?
24. Page 175.
Inquiry report has not been furnished to the petitioner and he was not allowed to cross-examine the witness and the inquiry report was not furnished to the witness.
Till that, maybe.
These are
it's
the
fine.
grounds which we can interfere.
Yeah.
Of course,
Yes,
subject to
yes.
what the record
Yes,
says so. And if you admit this, how can you challenge this?
There are 25.
I mean, technically,
But my lord,
you just,
yes,
para
I
24 and
I've seen it,
25,
I've seen
yes.
it. That's why my
You have
whole
not
case, my
controverted.
whole case in the read appeal is, these findings have come beyond the pleadings.
It would have been your contention could have been accepted on the face of it if para 25 was not there. That's what my lord is trying to.
Yes, I
Yes, sir.
understand.
So, what was
The
not-
basic ground,
But
the grounds
But the
normally in the
pleadings, my
disciplinary
lord.
proceedings,
pleadings
which
of
we
the
can-
writ petitioner,
just wait, which the court can interfere. If you don't controvert that, obviously,
it was controverted in the affidavit in opposition.
But a specific argument was developed in para 21 and para 24.
I've seen that.
And the corresponding, or you must say that this is perverse. Have you taken a ground in the appeal that this finding in 24 and 25 are perverse?
I have not exactly said paragraph 24 and 25, but regarding not just a moment.
maybe it is beyond the pleadings or maybe it's against the records, but you
I have-
yourself has not controverted.
I have taken one ground for that the learned single judge did not appreciate the fact that respondent authorities had categorically reverted the averments made by the petitioner in paragraph 21 of the writ petition while coming to the conclusion that the averments made in paragraph 21 of the writ petition has not been disputed by respondent authorities in their counter affidavit.
24. It's true. There is no doubt in this case.
Yes.
That the employee, who was the bank employee, he had done a misconduct.
And
And the law is very settled. Even if it is 1 rupee,
yes,
bank employee, the
Yes, yes.
yardsticks of determination would be different. But the procedure, you cannot. He may be, with Kasab, we have given him a fair hearing.
yes, yes.
So even if he is guilty, the fair hearing has to be there. That's what my lord is trying to point out.
Before that,
Yes,
Just a moment. I have.
You'll be given an ample opportunity
Sure, yes.
as you have been given in the discipline proceedings.
I don't have any, I just want to just.
Yes.
And,
My lord, इसको भी कैसे बोल सके
So Pani, I think you must again reframe your arguments.
I may have to because of what
Because why
has
is it-
been recorded
We
here.
can basically intra-court appeal.
Yeah.
First,
Because of what has been
we'll go
recorded
to the
here.
impute
I will
order.
try to go
And
through
then-
some judgments, whether a judgment can be passed beyond what is there in the records and all, my lord.
No, that will also not help you. That would have helped you if only para 24 was there. Now we have para 25 also.
Yes,
Right, wrong?
yes.
So now you got to show that even if para 24 and 25 is taken on the face value, from the records, this is purpose. So you will have to go to that extent.
Yes.
And being a bank employee, I think we should also try to see that whether he is entitled to any, he can be let out on this technicalities.
Yes, sir. Yes, sir. I will.
Because practically there is an admission on his part. But
What-
technicality we cannot
Something
ignore.
I should tell you, what my learned friend tells me is, after the arguments were completed, this written argument was furnished much later. I've seen it. It's a very big written argument, much more thicker than the,
Credit goes to-
yes. And unfortunately, this is.
That
Well, can it
written-
be some other day?
No,
I
that
have
written
understood.
argument will not have para 25.
Yeah. Written argument may have something that my learned friend did not reply to. Because that was not,
On the first blush, we thought you have a case. You may have, but in view of all this, because ultimately we'll have to see the impute judgment and all.
I have
Then we
understood,
can
I have
proceed.
understood, I have understood. That I have understood. But I will see, I will
But sometimes
go through the whole petition as a
Keep
whole,
the-
see,
Keep the original records also. Because
yes,
two
I
points,
have,
two vital points you will have to get to.
yes.
One, that inquiry report, but that I'm not very much sanguine. But the appellate thing, how it was done, because that also he requires a fair hearing. It should be. seen
That is
to be
what I
a
was
bit-
submitting, man.
That should be also be seen to have been done in a proper manner.
Yes.
So no bias should be creeping in there. So from your
But-
records, keep those also.
Yeah, I will keep those also, but I must point out, that is not even a pleaded case. Regarding the,
We may not even go into his contention with regard to the duality, two proceedings, criminal and department. In this case, I don't think so that issue can be raised. You may not permit him to do that. But the other points, you will have to get over.
yes, but this, the second point the Lordship is referring to regarding the appeal. His case in the appeal is that the appeal has not been decided yet. There was no pleading to the effect.
That's different.
That is why I was pointing out, I would rely on a judgment also, that these are beyond pleadings. That was, I was pointing out. This has come after the argument. This written argument was submitted, where these points were raised. It was not in the writ petition.
That was appreciated by the Honorable Single Judge. So you also have to now, because it's an intra-court. appeal.
That I understand,
if
but I
that is
would,
not-
but I also made an endeavor to convince your Lordship that beyond pleadings, the learned singles may not, could not maybe have.
For
Okay,
that, Mr.
when-
Manning, you will have to now recast your foundation
When-
and arguments.
This has, of course, created problems. for us.
it's good for the lawyers, London lawyers in the bench.
Can it be after around 3 weeks, my lord, subject to when he has said that he comes from outside?
Oh, you are coming from outside.
No problem, my learned friend wants to matter.
3 weeks or next week? 3
Not,
weeks.
not next week, so sometime in December,
Or
first week of
this,
December.
The
First week.
Senate Council for the appellate.
Difficult.
That's why my
Also
learned
have-
friend's convenience.
Mr. Ball,
After 10th.
what's your name?
Gautam Bol.
The Ball, London Council, appearing for the respondent. After arguing the letter for some time, the parties have prayed for listing the matter on the next day.
Mr.
Listing the
Bol,
matter.
don't think that we have disclosed our mind or we
No, no,
only want to
I'm
come
not-
to the
I'm
conclusion.
Yes.
insisting for a specific date so that
That will be given.
it will be.
No, no, the discussion we
List is
had,
better.
it's not a conclusion.
No, no,
It's only we are trying to
I have
understand
not
what.
started yet.
That's only we are trying to
At that
understand.
point, I have nothing to submit, but my request is specific date. So that-
If it was not
After 3
a,
weeks, you,
if it was not a bank employee, Mr. Bol,
So that at
you
any
choose
date,
the date.
you choose it.
any date after 15 to 20 of December. Whatever.
You
suitable.
decide.
You give a date.
You just give.
Okay.
Who is appearing for the? You are
Yes,
For RWD.
item 28.
yes.
What's there? You, I mean, it will be by, if you want, if it's, are you controverting that it's not his land?
Yes, this is already donated to BKB
By who?
by initially by one person, then in between he purchased the land and also he also donated. There is record to show
And after 2 weeks.
that.
And in fact, this is
Yes,
your news for that.
yes,
Doesn't
I
it?
understand. I understand.
But I thought I'll direct the state authorities to acquire the land and pay the compensation as per 2013 Act.
No, this is RWD project where there is no rural link road.
But then government has to acquire it is
Yeah.
private land.
Cannot
Well-
go through my,
It's not your fault.
Yes,
The authority as such.
we thought it's BKB's land. BKB have no issue.
Okay. BKB is a party.
no,
No,
not became his. I'm sorry.
He said BKB is the owner of the land.
No, no,
Let's be-
it's not that. I will.
Otherwise, why in the party if there is a controversy? And see it.
Yes,
That is 2017 matter.
yes.
yes, I understand.
2 weeks, no further adjournment. Mr. D. Fang, non-conservative petitioner. Submits the phrase for it, granted 2 weeks time. Mr. Jeter, non-conservative. Non-standing council for
RWD.
Roller Roads Department present. No, list this letter after 2 weeks.
I think state is also there.
Since the matter is of 2017, no further adjournment shall be granted.
No.
Well,
Your Honor, if I can mention.
Yes.
one Arbitration matter, which is arbitration petition number 6 of 2020.
Hmm,
Your Honor, this matter was first listed on 12th of July.
yeah,
The notice was issued to the state to file the reply. Your Honor, since then, the matter was listed once. And Your Honor, I'm requesting, convenience of this court to list the matter for tomorrow. For hearing.
tomorrow.
With simple section announced.
For?
For hearing and arguments of. Yes.
We'll see tomorrow. You are mentioning it for tomorrow, listing the matter for tomorrow.
Yeah, plead your lordship. My lord, I beg to mention item number 9, 10, 11, my lord. Here, my lord, we have, yes, my lord, 9, 10, 11, my lord. Here, my lord, we have filed our affidavit in regards to respondent number 2, my lord. But respondent 1 affidavit is necessary.
Hmm,
Respondent 1,
affidavit is
yes,
necessary.
sir. Respondent 1.
You
This
are
is
saying-
regarding framing of rules regarding charter of duties of FTS, my lord.
Hmm,
Charter of duties of FTS, my lord.
MTS,
Yes, ma'am.
okay.
In the police department.
Have you taken consent?
Yes, ma'am. After 3 weeks, my lord.
MSP or Learned Council for the Learned State Council submits that. Affidavit has been filed on behalf of respondent
Respondent
number 2.
two.
However, affidavit is required to be filed on behalf of respondent number 1, for which she seeks for 3 weeks time.
Yes, ma'am.
Praise the Lord. List this after 3 weeks, so as to enable the London State Council to file the affidavit in operations on behalf of respondent number 1.
My lord, I beg to mention item number 24.
24,
Yes.
yes.
My senior counsel is out of station due to his.
We'll say
family.
it's in order column. Orders column. We'll see. Wait for your turn. We'll see. Wait for your turn.
And your honor, there is one more item, item number 27.
27, no adjournment. Basically, you want that department should furnish you all the documents.
My lord.
You file an RTI. Why this
Yes.
High Court is better
Oh,
as a commissioner RTI?
my lord, no, my lord. My humble son, ultimately,
What is the instruction?
Yes.
You withdraw and file fresh. Nothing. Your prayer is only for supply of documents.
my lord.
Furnishing of grounds.
I have addition to play, my lord.
What is the addition?
Addition, my lord.
Let's see.
Ultimately, my lord will appreciate the law that my lord, this transparency and fairness, my lord, is the very basic requirement of any tender, my lord. Now, the transparency demand, my lord, we may be allowed to have access to the documents submitted by the other petitioner, my
You
lord.
just see
Other-
prayer
sorry,
number
my lord.
1,
Yes, my lord.
page 25, prayer number 2. Then ultimately setting aside of
One, my lord,
somebody. That's all.
my lord. Two, my lord. Two
What
is
the-
two
Page 26.
26,
Mr.
my lord.
Missing, page 26, please. What is this? Post is ipso facto, what is this? It is beyond my comprehension. Who has drafted it?
Three, I will not press, my lord. Two, my lord, I'll pray for, my lord.
What is
Three,
ipso
two,
facto
my-
is what? What do you mean by this?
consequentially, my lord.
Ipso facto to direction to, I don't understand.
Consequential order, my lord.
Huh?
Consequential order, my lord.
Have you checked up?
My lord.
Have you checked up the dictionary meaning?
Yeah, I believe, my lord.
Huh?
I believe, my lord.
Why unnecessary these words has to be burden? Unnecessary troubling the word ipso facto. Don't trouble them.
Two, my lord, I will pray. Now,
Let them be sitting where they are appropriate.
my lord.
Correct?
Noted, my lord. Now, my prayer, my lord, prayer number 2, my lord, would be relevant, my
To
lord.
set aside.
No, not for setting it. I'm not, today I'm not for setting it, my lord.
Ah.
I'm saying, my lord, ultimately, my lord, transparency, my lord, is a very basic
Prayer
requirement.
number 2 is what?
I'm praying, my lord, direct the respondent, my lord, to enable the, my lord, website, my lord. So is,
Yeah, that will direct. No issue.
Yeah, he
Yes,
can.
my lord.
I'll just immediately I'll dispose of and give a
Yes, my
direction. To enable
one,
the
my
portal.
lord, yeah, my lord. So that
Enable
I,
the portal.
portal, my lord, so that I can have access the document submitted with other bidder, my lord. That is the,
Then we'll direct that.
The portal is always open. He
Oh.
can access.
no, my lord.
The recorded submission will direct you to what do we call?
To access the portal. Web
To
portal.
enable the portal window website so and so.
My lord. So that I can access the document submitted by the other bidder, my lord.
Why have not enable it?
I
Even
don't
my
think
lord-
It's closed, it's always open.
No, my lord. Even I have recorded the video also, my lord. I have clear instruction, my lord. We have a video recording also, my lord. That is not enabled, my lord. Till filing of this petition, my lord.
Heard Mr. L. Are you sure?
Sure, my lord. We have a video recording also, my lord. Trying, my lord, to go into the website, my lord. Till filing of this petition, that was not enabled, my lord.
It can
This
also obtain from the division office also.
This,
Ultimately, my lord,
sir, this would be the one of the least grievances which the litigant had sought from the High Court under 226.
See, my lord, my lord will appreciate.
He said you have a faith on him. He said it has been enabled.
My lord,
We'll take after some time, go back and check it. Or go outside and check it.
I will submit, my lord. I will submit it, my lord. This may be disposed, my lord. We have direction. Let
I am indicating you file a better petition than this.
surely, my lord. Surely, my lord. I will pray, my lord. Let
Withdraw.
no, my lord. Not this may be disposed, my lord. With a direction, my lord.
Heard Mr. L. Perme, learned counsel for the petitioner, and also heard Mr. G. Tarak, learned counsel for the petitioner. Learned counsel appearing on behalf of the state respondent. Learned standing counsel, huh? Mr. L. Perme, learned counsel for the petitioner, submits that he is not pressing any other prayer which he has made in this writ petition, except the prayer number 2, where it is provided that, prayer number 2, please come. Mr. G. Tarak, learned counsel, learned standing counsel, submits that the prayer made in this writ petition cannot be accepted, cannot be accepted as because the portal window of the website pertaining to NIT has already been enabled. Please stop. Next question. Having considered the submissions, which this court finds to one of the least grievances in the 226 under Article 226 proceedings, this court dispose of this matter, writ petition with a direction that the respondent authority shall enable the portal window of every website pertaining to NIT number so and so, so and so, so and so as to enable the petitioner to access the bid documents submitted by other bidders in the tender process, which according to petitioner is a part of a fair and transparent process in the bidding process.
High level. High level.
Accordingly, this petition is closed. You take it back. We're not concerned now. Take it back.
This is a bizarre case in Arunachal. For the first time, there is an interpolation of the age at the fake end of the service and will continue till 2026.
Who are you? Who
So-
are you?
I'm heading a forum.
Huh?
I'm heading a forum, a spirited citizen.
So it should be PIL.
Co-warranto that Avasti judgment, paragraph 31.
That's why I'm asking. Who are you? If you are heading a forum, if you are having a forum, either PIL, and of course you have the hurdles.
Yes.
Recently, the subsequent bench has doubted the
Correct.
proposition of law
Correct,
that
my lord. That
PIL may not
may not maintainable.
maintainable in service matter. So, but then it has not been decided.
Not has been decided.
They have observed that it may be decided in other appropriate proceedings.
Notice, man.
So, man has retired.
No.
Why you have allowed?
First of all, whether such kind of writ petition is maintainable or not, that also has to be seen.
As I have indicated.
Yes, co-warranto, lordship is aware, in which cases co-warranto can
That's
be.
why who you are.
With some kind of general issue, like my.
But this cannot be permitted also.
Yes,
Forget about the maintenance.
that's different thing, madam. That's totally different thing.
But we'll just, forget the maintainability. It be permitted.
That has to be looked into, my lord, departmentally.
But from the records, it shows. Initially, he was in date of birth is somewhere into 1961. And after observing in the other department you become in 1966.
Definitely, madam, the private
It is- it
respondent
is-
will have to answer, madam. That's a different aspect of the
So we'll issue notice, open the, we'll keep open the mentality, issue of mentality.
Yeah, just I place that parent.
He's raising the issue. You file an objection and on maintainability as well as on merit. We'll see. First, we'll decide the maintainability and. then you know, we'll
Otherwise,
have-
madam, it's sometimes it harasses the officials who are working, madam. That's more particularly engineering department, madam.
You cannot
Hmm.
allow a person
No,
to
that's
throw the
different, madam.
public exchequer,
public
drain the
money.
public exchequer in this
It's a public
manner.
money.
Take action and come back.
No, it is not a person, officer who is not authorized to function.
On maintainability, you will have a hard time. On merit, he may have a hard time. Both standing.
I will not have. madam. I have the authority right now.
And Mr. Titi Tara, learning council, with the police. We'll just issue notice. I'll not record the. this
Yes,
person,
Yes,
Because
usual-
maintainability, this code is also there that it's not maintainable. But
we
I'll just issue.
subject matter of the examination.
uh, issue notice to the respondents. Private respondent is there?
Yes.
It is there.
The reason I'm not saying what.
No,
you
no,
have
no
read,
issue,
what
madam,
you
no
have
issue.
read, huh? The Mr. Peter, London Council, London Standing Council appears on behalf of respondent number
2 and 3.
2 and 3.
Yes.
MS
For one.
R. Basar for respondent number 1. Then you first R. Basar for respondent number 1, huh? London still council. The London Council for the position steps be taken for service of notice upon the respondent number 4.
Usual course as well.
It is supposed to be as well as usual process. Within 2 days, extra copies will be furnished to the London Council for the respondents of state respondents. The issue of maintainability of this petition shall be heard on the next date.
Yes.
You file affidavit,
Yes.
preliminary objection on maintainability and also merit.
Yes.
We will not let him just go like that.
Yes,
Correct,
will
madam.
do.
Yeah, our serpent is being allowed to hold the fort. Avasti case is very clear on how I can claim written forward.
But as stated in the writ petition, irreparable loss and damage to him, madam. I don't think that's.
To the
Cost
state
to him.
exchequer, Lord. To the state exchequer.
That's a different thing,
okay.
madam.
We'll see. Returnable with 3 weeks, huh?
Please, madam.
Yes.
Father, the item number 3 and 4 are the similar method.
Okay.
Despite that the separate petition has been filed, but
Yes.
these are the common prayer.
Hmm.
So after going through this item number 3, will cover the item number 4.
Yes.
Now, the question involving in the, my lord, NIT in the page number 19. This is the, my lord, NIT, which was, my lord, called a tender on
Page 19,
19, my lord,
19.
19.
Yes. Which date? NIT dated?
That is 27th,
Where do we find it? Where do we get it?
my lord, we shall get in the, my lord, we go back to the page number, my lord, 18.
The date of receipt of which will be. Page 18,
My lord.
where it is?
My lord, they stole a
Date
tender
of
on
release of the invitation.
27/9/2023.
Okay,
Thereafter, my lord, in page number 19, column number 7.1, it is shown that to be announced later, date and time for opening of the part 1, that is the bid technical qualification part 2. Now, my lord may kindly come to the page number 21. This is the, my lord, minute of the
Time and date of opening part to be.
Yes, my lord, note that has been put, particularly in this, this is the my lord impugn before the lordship, wherein my lord, we
Technical
have
bid.
received it, my lord,
Minutes of the technical bid evaluation, huh?
my lord. And now in the, but in page number 21, I am in serial number 2, my lord, Eka Enterprise.
Yes.
Here, my lord, the region for non-responsive has been shown as appendix 2, ITB 4.4B, B1.
Yes.
So, my lord, may kindly come to page number 31. What is there in my lord? ITB 4.4B.
ITB 4.4B,
Thirty-
B, small b,
B,
page,
H, 31, my lord,
page 31.
31. This is the standard bid document for
Yes.
PMGSY, page number 31, lordship will find 4.B, B1. Availability for the construction of the work, either owned by or on lease or on hire of the key equipment stated in the appendix to be ITB, including the equipment required for the establishment of the field laboratory performed in the mandatory test and those stated in appendix. So, my lord, this is the ground that I have not submitted this document.
Okay,
So, this is appear in the page number 52,
52.
my lord.
Your documents or the format?
This is the format. My documents will be
Page 52.
52.
Yes. Bidding documents and so. That's difficult.
My lord, this is the format. So where they record 21, start from serial number up to 21 item, my lord. So for the allegation is concerned that, my lord, allegation is that I have not submitted all these document, my lord. So my bid is non-responsive. I have been rejected. Now,
Yeah.
lordship may kindly come to the page number 133.
Your documents.
Yes, this is my document, what I have submitted before the, or at the time of my lord, tendering.
Yes.
This type out copy in the next 133A in the form of affidavit, and this, my lord, this document I have downloaded from the, my lord, website of the department. At the time of, my lord, filing this bidding document, my lord, these all documents were already been submitted.
You are required to file 19 items.
My lord.
Page 52. Or how many items?
As per page 52, my lord, 99 items.
Then it continues up to 38.
30.
And then B 1 to 15.
My lord. So, my
So
lord,
many.
all
many.
require what has been in page number 51, my lord, that my submission is that I have submitted. So this page number 133A is my document that.
But you have
I-
submitted only 23. There are so many items.
My lord, despite of that.
When you compare with that page 52, starting from page 52, so many items. Not only 30, then 15, then 19. You have only submitted 23. There may be a discrepancies.
My lord,
That's all.
so far, my lord, this serial, my lord, 4.4B, 1 is concerned, subclause 1 is concerned, my lord. It has only, my lord, up to the page 20 item. And that I have submitted.
20 items.
Yes,
20 items.
my lord.
Let us see. How I find
Page 51, my lord. My lord may come back to the page 51 again. Equipment of organic machinery, which has been shown in this standard bidding document for PMGS1.
Yes. B1B.
And these other are, my lord, they were pertaining to the bridge work, and these are, which is not, my lord, applicable.
Item 19 on 20 only,
20 only,
according to you.
according.
And next one is what? It's not legible also.
My lord,
Next, page 52. What is the mark one? What does it read?
my lord.
Page 52. Just above the box.
In case of the, my lord, the work following in case of the bridge work, my lord. This is, my lord, in case of the bridge work. Which
So
is,
it's not a bridge work.
it's not, it is only the
The
construction.
construction is not,
No,
there's no bridge work.
Yes, ma'am. So this is not relevant, ma'am.
I don't think so.
There was a, my lord,
There's no road,
construction of-
there's no bridges also.
My lord,
No
this,
bridge.
my lord, this has, in the standard bidding document, this has been shown. In case of, my lord, bridge work, if any particular bridge is advertised, any NIT is called for the bridge, then only, my lord, these documents will be required. But in case of construction of the road, in the present
Road
case, my lord,
includes bridges.
this is not necessary,
If
my lord.
bridges is not constructed, I mean, what's the meaning of having a road?
My
If
lord,
there is, according to you, there is no bridges
my lord,
in this particular segment,
my lord,
is it?
my lord.
Sure.
Yes, my lord, because this was not the part that I should be annexed. But so far only the concerning to the construction
Show
of road.
Show me
Despite that, they, my
Show
lord,
me from the ITB.
my lord, this present 51 and the 52 are,
Each
my
bidder
lord, this-
must produce. Each bidder must demonstrate. Appendix to ITB. It's a part of appendix to ITB. You have to annex. And you have only given 23 items.
my lord,
There is so many.
23 items,
Only first page, it's 19 items.
my lord,
You have submitted 23 items,
my lord,
prima facie.
my lord.
And when you read this page, 4.4,
4.4
B, small
subclause
b,
small b.
one, when you read this, you just read this.
Yes, my lord. So
Availability
in order
of
to read it, my
construction.
lord, come back to page number 31.
Yes,
Availability for construction of the work, either own or on the lease, on hire of the key equipment stated in the appendix to be ITB, ITB, including the equipment requirement for the establishing field laboratory to perform the mandatory tests and those stated in the appendix. My lord,
it is stated in the appendix B, ITB.
my lord.
Includes not only the first phase of 51, it includes much more. So, police should notice nothing.
My lord.
Notice is also, it also doesn't deserve,
Yes.
but then Mr. C. Modi is appearing. Heard Mr. C. Modi, Learned Counsel for the petition. And also heard Mr. G. Tarak, Learned Counsel for Learned Standing Counsel for the State Respondents. And then the Rural Works Department. By filing this application, the petitioner has put to challenge technical bid evaluation. That's it. 1311. Your rejection is on
My rejection is on 10-11 or 10-11 month.
let us see the rejection. Where it is?
In page number, my lord, 23.
23.
And it has been, my lord, shown on 12 November. Despite that, my lord, this was on 10,
Page 23 or page
23, my lord.
where it is? This is annexure number 2, 3.
3, my lord. This is this is the, my lord, particular that wherein I have been shown that I am, my lord, non-responsive. In fact, my lord, I come
No,
to
in
know
that case, page
a-
21.
after
Page
31.
21. Page
21.
21. Page
Eh,
21.
Yes, my lord, 21 is the evaluation bit, man. Minutes of the evaluation bit.
The rejection is.
No, no, this is the annexure 2 and the no that is there, man.
technical document
After
summary.
13 only we come to know, man.
No, in that case, we'll go to page 21.
21.
This is which date?
Open on 1810 in presence of bidders. Technical was open on 1810.
1810. The qualified bidder has been conveyed to attend the financial bid on, okay. They put to challenge the minutes of technical bid evaluation, whereby the bid of the petitioner is found to be non-responsive in view of the non-compliance of appendix to ITB dash 4.4 capital B bracket small b bracket close bracket 1 bracket close. Next paragraph. Mr. C. Modi, learned counsel, referring to the documents annexed in the writ petition, submits that the petitioner has complied with the requirements of clause 4. So and so, same clause, by submitting all the documents. However, the respondent authorities, for that matter, not respond, the bid evaluation committee has found to be non-responsive without considering the documents submitted by the properly considering the properly evaluating the documents submitted by the petition. Issue notice returnable in 4 weeks.
My lord, if my lord till return or 4 week, my lord, this is pertaining to the tender matters. So my lord,
3 weeks.
status quo be my lord,
3
my
weeks.
lord.
3 weeks.
Here
Is
secretary
the-
are the.
is there a private respondent?
My lord,
No private respondent.
private respondent, yes.
Is it private respondent?
Yes, my lord, two
Okay.
private respondent.
Okay.
Two
The-
selected to be the
Since the Tarak Barnett Standing Council appears on behalf of respondent number 1,
One is chief secretary.
no, the respondent number 2, 3, and 4.
Secretary is not party here again. Secretary RWB.
No common notice need be served. However, extra copy is served to the
private.
appearing private respondent authorities. Who is appearing for? You are appearing. MS K1 move. Then State Council for respondent number 1. First you read that, then come to Jitara. Extra copies, other extra copies be furnished to the appearing councils. Steps be taken for service of notice upon the respondent number 5 and 6. The register goes with the usual process within 2 days. It's after 3 weeks. Same order.
For same order.
Same order. Out of same,
Only the petitioner's name, everything same.
you just add that, C Modi Learned Council is pursuant to the NIT dated so and so. NIT page 20, page 18.
Madam.
Page 18, you check. Same order,
Sorry, madam, this should be page 21.
21, NIT. You just get it the NIT dated so and so for construction of so and so. Attender for name will be different, Same NIT, same one. Yes,
My lord, I am the petitioner in this case.
Yes.
In the last occasion, I have implemented petitioner respondent number 5 and 6
yes,
as a necessary party,
okay,
and copy has been already served
okay.
to the respondent number 4 and 5 and 6. Your Honor.
My lord,
Your Honor,
I am appearing for 5 and 6, my lord. I pray for some time, my lord, to
You are
file
appearing for
5 and 6, my lord.
5 and newly applied,
Yes.
implemented. Newly implemented.
My lord.
Mr. So-and-so learned counsel appears. Learned counsel for petitioner. Heard Mr. So-and-so, learned counsel for the petitioner. Mr. Ram, state council for, learned state council for 1, 3 and 4. Which court 2? 1, 2, 3 and 4. You got court 2.
The Kamdung, my lord.
Mr. So-and-so appears on behalf of the committee. Mr. L. Permit, learned counsel, Summit State. He has an instruction to appear on behalf, respondent number, newly implemented respondent 5 and 6,
My lord.
for which, and raise for 3 weeks' time to file affidavit in opposition.
How will
As allowed, list is made after 3 weeks. Non appears on call. MS Arbasat,
No.
London Council, London State Council appears for
1 and 2, all, Your Lordship.
all
All, Your Lordship.
of the respondents. List after 4 weeks.
Right, Your Lordship.
Well, here record was called for.
Hmm.
Record. Regarding the transfer matter, madam.
Yes. Do you have the record?
Yes, madam.
Just recap.
Yes, madam. Madam, within 2 years, I've been transferred 3 times, madam.
Okay.
So, madam, see, madam, phase and lecture 3, madam, is the interim order, madam. Page 19, 19, madam.
19.
19, madam. And lecture 3, 19.
This year. Yes.
Here, madam. My name is
Serial number 2.
Yes.
Video.
Yes, madam.
Video.
02
From 0 to
Jenging. madam.
actually to Jenging.
Yes, and this serial number 1,
Hmm.
private respondent is brought in my place, madam.
Hmm.
Reported, my lord. My lord, they come to the page 16, my lord. 16, madam.
Hmm.
16 type copies at 17, my lord. Type copies at 17, my lord. By this order, I have been transferred from Daporijo to
Actually,
no, my lord, Itanagar, my lord, RW. It is-
17.
Yes, ma'am. 17, my lord, 20th July 2021.
Hmm.
And in 22, my lord, again, next page, my lord, page 18, my lord. Here, my lord, my name is serial number, my lord, 3,
Hmm.
and private respondent,
You have no issue of these 2 transfer orders?
yes, no issue, man.
You don't.
So I complied with my this
Yes.
transfer. Then, my lord, this impugn order, 3rd time, madam. Private respondent was sent to the Jenging, from Trijona to Jenging, and I've been sent to actually from Directorate RD, madam.
Page 17 also modification order.
Yes, 17 is also modification order, madam. And
20th July.
yes, madam. Then page 19 is the impugn order, madam.
Yes.
So I am, my lord, victim of the pregnant transfer, my lord. And this pregnant transfer order was issued, my lord, in order to accommodate this private respondent, my lord. And both the private respondent as well as this petitioner have not completed their tenure also, my lord. And this private respondent was brought in my place on the
After every 1 year.
after every 1 year, my lord.
It's
Yes.
good, yeah. Do you have the idea how we're
My lord.
almost on the wheel every 2 weeks? Not within the state. We're within the state every 1 year.
Every 1 year, my
Where after every 2 weeks or 3 weeks. From one state to another state. Another bench to another, one bench to another bench.
but my lord,
You
yeah.
are lucky 1 year at least.
But my lord, that's amount to the pregnant transfer, my lord.
So what about this court? Every 2 weeks to one state to another state. Anyway, it's okay.
This transfer order was made.
Nowadays, every 1 year you have been transferred. Every after 1 year you have been transferred,
Yes, my lord.
which amounts to frequent transfer.
Frequent transfer, and
My
it is done on the intervention of the my lord, education minister, my lord.
All the transfer orders,
No, not all of the interim transfer order, my lord.
last impugn transfer.
Yes, my lord.
How do you say?
Yes, my lord. In my lord, reply to the IA,
Hmm.
I've annexed the your note, my lord.
Where it is?
Yes, my lord. Affidavit in opposition to the IA, my lord. Annexure A, my lord.
Hmm.
At page 7, type copy is at page 8, my lord. Reply to the IA, my lord. Affidavit in opposition to the IA.
Yes.
Page 7, type copy is at page 8, my lord. Transfer posting of Taro private respondent.
Like to recommend the transfer to You have been to actually for 1 year.
Yes,
You are still there.
still there, my lord.
Just stay.
Stay, my lord, stay.
Here. Just because a note has been mooted, it doesn't by itself make the transfer of the bed.
Yes, my lord. Sir, in substance of my contention, writ petitioner, my transfer is pregnant transfer. my
Only
lord.
he has asked for bringing the private respondent, Taro Blange.
Yes, my lord. My lord,
So
Pregnant-
he didn't say anything, indicted anything about you.
yes, my lord. I have one, my
So
lord.
he has, he may make a proposal.
Yes, my lord.
There's no wrong.
Yes, my lord. But my lord, pregnant transfer without assigning any reasons for allied purpose, my lord, not the proposed purpose, my lord, in order to accommodate the all persons is amount to malified, my lord.
Let's say it's a press transfer order, it's not modification order.
Well, pregnant transfer, my
Yeah,
lord.
maybe it has to, but every transfer cannot expect any reason as such, a particular reason.
My
It
lord,
has to be decided by the authority.
in my case, my lord, it is pregnant transfer, my lord,
Frequent after every 1 year. Not that within 1 year.
without assigning, my lord, any reasons. And it is not for the proposed purpose, my lord. And not for the public interest, my lord. My lord, may
Why
I?
you want to be there for so long? You have been there since when?
Since, my lord,
June,
June,
more than a year.
more than a year,
Wow.
only more than,
You are about to complete.
yes, about to complete, my lord.
June, another 6 months.
6 months, yes, sir.
Doesn't matter.
But regarding pregnant transfer, I have one authority, my lord, of the our apex court, my lord. Reported in the air, 1986, my lord.
Is it similar that after 1 year?
That the ratio has been laid down, my lord, regarding pregnant transfer. What is the pregnant transfer? That has not been laid down, but pregnant transfer ratio has been laid down, my lord. At my lord, will find at para 5, my lord. Principal will apply, my lord. My lord will file at para 5, sub para, my lord. Para 5, sub para, my lord. Para
It is an accepted, right?
Yes, it is an accepted principle that in public service, transfer is an incidence of service. It is also an implied condition of service, and appointing authority has a wide discretionary in the matter. The government is a best judge to decide how to distribute and utilize the service of its employee. However, this power must be exercised honestly, bona fide, and reasonably. It should be exercised in public interest. If the exercise of power is based on external consideration or for the achieving an alien purpose or in oblique motive, it would amount to malified and tolerable exercise of power. Frequent transfer without sufficient reason to justify such transfer can be held as malified. A transfer is malified when it is made not for the proposed purpose, such as in normal course, or in a public or administrative interest, or in exigency of service, but for the other purpose, then is to accommodate another person for undisclosed reason. It is the basic principle of rule of law and good administration that even administrative actions should be just and fair. And this ratio has referred to the constitutional bench, my lord, judgments, my lord. It is a E.P. Royapa versus State of Tamil Nadu, reported in 1978, AI 1970 SC 555, my lord. This particular ratio observation in this, my lord, judgment refer to the E.P. Royapa versus State of Tamil Nadu, my lord, reported in AIR 1974 SC 555, my lord. We are in the last para, they rely on the observation made by this court in E.P. Royapa versus State of Tamil Nadu and others. It is dear, my lord.
It's okay.
So in my case, my lord, there is no reason.
This is the which you have read.
Yes, my lord.
This is a paragraph of E.P. Royapa's case.
E.P. Royapa's case, paragraph 85, my lord. Yes, 85, my lord.
This is been quoted here.
Exactly not quoted, my lord. My lord. Exactly not quoted, my lord.
It was observed.
Observed, my lord. Yes, observed, my lord.
This E.P. Royapa was I have relied on in a transfer, the first case of transfer which I have appeared in this bench at Nahar.
Might be reported, my lord.
2000.
I have not come across, my lord. Might be
No,
reported.
it's not reported. Ultimately, I think it has had a natural death. There's no decision as such. I'm just saying, sharing that this I have relied in 2000 when I appeared in the transfer method. First transfer method in economy where I have appeared. Okay. Anything else?
That's
Yes. Any justification? Why it has to be transparent, why the private restaurant has to be brought in?
Yes, it is an admitted fact that as per the office record, Your Honor, this petition has been transferred due to the EO note issued by the minister concerned. But he is the local MLA of the area.
There is no bar.
Yes, there is no such bar. Because, this matter has been settled in Kemolal case. Kemolal versus State of AP. No, Your Honor.
This is the same. Okay.
Your Honor, may I, Your Honor? Now, Your Honor.
Where it is?
Yes, Your Honor. Oh, Kemolal
Yes,
case.
where it is?
Kemolal, 2018, 5 GL.
What it says?
It says, Your Honor, a recommendation by MLA cannot
By
vitiate,
itself,
yes,
it's not vitiate.
will not vitiate the transfer process.
Appreciate the transfer. Maybe on the basis of Muhammad Masud.
Yes, yes, yes. Para 23 and 24. Yeah. May I read, Malad? Para 23 and 24.
Yes, Muhammad Masud.
Yes, it has been relied. Malad, and Govardhan Lal, Your Honor, says on violation of guidelines, they cannot maintain writ petition. Violation of guidelines.
He is not said so.
Frequent transfer 1 year, he is taking the center of 1 year. By relying on the circular, page 22. This circular does not help him because he is a Group A officer. As per the circular of 2 June 1998, Annexure 4 of his writ petition, no officer of Group A and B should be posted in his home district so that he does not develop vested interest. This is the home district of the writ petitioner.
Who follows that?
Yes, sir. That's why one of the guidelines are not mandatory. He cannot maintain writ petition for violation of guidelines. And then the writ petitioner has alleged malafide against the minister, but he has not made it as a party respondent. In that case, Your Honor, I will be relying on 1995 Supply 4 to 89. Dr. J.N. Banwalkar versus Municipal Corporation of Delhi.
Single bench.
Supreme Court. Apex Court, yes. Para 21, my lord.
In the facts and circumstances.
Yes, ma'am. May I read? In the facts and circumstances of this appeal, it is not possible to hold that the impugned action is in removing the appellant and appointing Dr. Patnaik is unfair or unjust or irrational or arbitrary or tainted with any malafide intention. The contention of the applicant that in order to accommodate a junior doctor as medical superintendent in ID hospital, Dr. Patnaik had been moved out from the said hospital to replace the appellant as medical superintendent of so-and-so hospital. Is not only vague but lacks in particular, forming the foundation of such contention. Further, in absence of implement of the junior doctor who is alleged to have been favored by the course of action leading to removal of the appellant and the person who had allegedly passed malified order in order to favor such junior doctor, any contention of malified action, in fact, that is malice in fact, should not be countenanced by the court. This appeal therefore fails and is dismissed without any question.
Here he has made private respondent.
Yes, but this person, minister, if he is saying that there is malifiedness has been alleged against the minister, so he is a necessary party.
There is a division bench of this court, 2016. Maybe this is in the facts and circumstances of that case.
Yes, yes.
Where it says, it's not in all the cases, if an allegation of malafide is there, should be a party. Normally it should be.
Yes.
But here, he wants to say that just because the minister wants him to be bring in, so
Yes.
he has to be transferred without
Yes.
there being any public interest.
But Kemulalan
Not
says
alleging a personal malafide. As a minister, he favored him,
yes, sir.
so he had to grow.
Yes.
That to that extent,
Kemulalan is clear. Recommendation by MLA cannot vitiate the transfer order.
that we cannot dispute.
Yes. Other else,
But
my lord,
to-
there is no.
to- Why you have to discriminate?
This is not.
What is the reason?
Considering the recommendation is not violation.
Why you have to bring him?
I have considered the representation of the MLA concern or minister concern. He is
Why?
also the local MLA
Why?
of the area.
So you don't have your independent assessment
No, no,
of the
we have,
officers?
we have applied our
You
mind.
are go by what MLA says and what minister says.
No, no.
Is it?
No, no. Yeah.
Is
We have
it your
applied our,
function as a secretary?
no, no, we have applied our mind, the file has been
Mr. Mitra,
processed.
is it your function as a commissioner secretary of the department?
No,
You'll
We-
go by whatever MLA and the minister say.
no, no, madam.
Is it?
We have applied our mind.
I'll record your statement.
We have applied our mind.
What applied?
This is a file noting here.
Where is the, what shows it? Record shows what? There's nothing.
It was
You have
processed.
acted on the recommendation of the minister only. That's all.
No, there are file noting here. Of the
Where?
first page. From the first page. only.
Where's the reason? Where's the reason?
It
Tell
is
us.
solely on the recommendation. Yes, Your Honor.
Where's the reason? Tell us. There's nothing.
It is on
That's
the
why
record.
precisely wants to see the records.
Yes, Your Honor.
You said
Yes, ma'am.
that.
It
makes
is on the
us a
record. Yes,
solution.
ma'am.
That means you don't have an independent assessment. You don't know, you don't have a control over your officers.
No, my lord.
You
There
are
is
just a stamp there.
no, ma'am.
You're just a rubber stamp in the office.
No, no.
The head of the department.
No, no.
That somebody comes and transfer this and transfer that, then you'll sign and do it.
We have also the authority
Very
to reject it, my
unfortunate.
lord.
Who is the officer?
Secretary, Your Honor.
Who is the secretary?
Amarnath Talwade.
He must be an IS officer.
Yes, Your Honor. We can also reject the recommendation.
Is it your instruction to submit before this court like that?
My lord, this is a record, my lord. I cannot
Have
submit
you
beyond
been
record.
instructed to submit that?
No, man.
That we just act on the recommendation of the minister?
No, no,
And
we
the
have
MLA.
acted upon it, my lord.
I'm sorry.
We have made some assessment, my lord.
You have
We could
acted,
have
you
rejected it
have to
also.
assess.
Yes, my lord, we could
You
have
to
rejected it
consider.
also.
I'm not saying that you cannot consider the
Yes.
recommendation,
Yes, ma'am.
but you have to consider with reasons.
Yes, ma'am.
Please proceed.
Yes, ma'am. And that, my lord, finally, my lord, transferring of the petitioner from his place of posting does not affect his right, service condition.
Yes.
So no right of the petitioner has been violated, Your Honor.
That is all settled proposition.
Yes, sir. That is my submission.
There, what is there? Nothing.
My lord, can you pick up page 8 of the additional affidavit?
Additional affidavit or IA?
No, additional affidavit
By whom?
by the petitioner.
Yes. Where it is page.
Page 8, last page. My lord, I have already read it. But still. Page 8, like.
No, that is in
Note of
IA. IA objection to your IA.
objection to my IA.
Yes. Yes, not I have read it.
Yeah,
There's nothing against him.
yes, my lord. So,
Minister has just requested the concerned minister to transfer their respondent.
correct, meaning thereby no aspersion has been cast on him, nothing adverse against him. Therefore, the read petition has been filed on the basis of allegation of a mala fide. If there is no mala fide being established, then the petition cannot be sustained. For the reasons I placed this, my lord, that there is Durgeshwar Kumar judgment, my lord is aware that 2020 19 SSC 46 para 7. Employee cannot have a choice of posting. Para 17. my lord. It's a division bench of the Supreme Court by the Chief Justice, Honorable Chief Justice of India. We must begin our analysis of rival submissions by adverting to the settled principle that transfer is an exigence of such service. An employee cannot have a choice of postings. Administrative circulars and guidelines are indicators of the manner in which the transfer policy has to be implemented. However, an administrative circular may not in itself confer a vested right which can be enforceable by a writ of mandamus, unless an order of transfer is established to be mala fide or contrary to a statutory provisions or has been issued by an authority not competent to order transfer, the court in exercise of judicial review would not be inclined to interfere. This principle emerges from the judgments which have been relied upon by the appellants in support of their submissions and so and so and so. So, my lord, unless or until if the allegation of mala fide is not established, my lord may have to restrain in view of this judgment of the apex court in interfering this incident. Now, the second contention that my lord have raised by my learned friend is a frequent transfer. Now, prima facie, my lord, two orders have seen first from Jinging to Itanagar, direct Dapo to Itanagar, my lord, and then Itanagar to Yachilim, and has completed more than 1 year of the posting. Then that proposition, my lord, of frequent transfer, my lord will recall that Pojum Padu's case, assistant engineer, PHE and WSD, my lord. This gentleman was transferred 4 times in 1 year, 2 years, 4 times in 2 years. And here, the petitioner could not establish the violation of his fundamental and the legal right on the threshold of mala fide, my lord. There's a, my lord, just I indicate a paragraph 2012, 2011, I'll not burden my lord, just I indicate the paragraph. 2011 to GLT, page 186. Paragraph 8 is most important. That I just indicate.
Paragraph?
Paragraph 4, 8, 10. 8 is main, my lord. The instant read petition is to be disposed of on the basis of the established service law, particularly law regarding transfer of employees. It is not necessary to elaborate or reiterate that government servant has no vested right to remain posted at a place of his choice, nor can he insist that he must be posted at one place or the other, because no government can function in such manner and the government servant is liable to be transferred in public interest. Exactly, my lord, there is a word used, sentence used at page 8 of the minister noting, my lord. It says in interest of public service.
Paragraph 8.
8, yes.
Page, this citation is
My lord,
2011 to GLT
2 GLT 186.
235.
No, no, no. Page 235. No, no.
235.
The wasn't father. This is what mine is correct.
No, it is Kagotabio.
186. 186.
186.
Yes, I think something wrong flagging is there. He was transferred to the Justice Musari. 2014, sir, and Nani Long was the counsel here.
185.
86. 186.
There is also transfer. Kagotabio is also transfer.
Correct.
Same.
Same. Now, the third limb of argument I would put in a very precise manner. Violation, I will not place that lordship. Very precise, this transfer and thing. It is a decision.
Why burden with all this such
No. Well, this is purely an administrative act, my lord.
Just note down all those.
Yes. Administrative act, my lord. So in that view, if unless Malabhaide is not there, normally the
Why?
constitutional courts would eschew from interfering in such kind of administrative decision. That is, my lord, para 14. My lord knows Kashmir Singh judgment. Kashmir Singh. Para 10, just I am giving it. Para 14.
It's okay.
Now, my lord, fundamentally, my lord,
Do I need to look into it?
yes. Now, my lord, the last theme of argument. Paragraph 14.
14.
Purely administrative. Then, my lord, kindly, my lord is aware. Govardhan Lal case, the principal, my lord is aware. So we will not reiterate on that. Then Shamsher Ali is also is there, you ought to have relied. There were malafidiness. If malafidiness will follow if there is a violation of statutory rules, Miller. Even if it is violated, then malafidiness has to be proved. Then only read can proceed or interfere in the transfer.
The difficulty is on the basis of your note of the minister for the MLA. He has been brought in and he has been transferred. Is it a
No, that's why, Miller.
fair action?
No, Miller. That will not be my limb of.
Because this doesn't, so we'll go by the records. That's why I had a thing, because he has admitted, we have just acted on it. I'm not saying there cannot be hard and fast rule.
Correct.
But the law that you cannot act on the request of the minister or MLA. That you are jumping out somebody, your own employee. You have to assess and you have to decide. You apply your mind as a authority.
That celebrated judgment my lord used to quote Mahendra Singh Ji case. One should not mortgage the power. Probably if lordship look at this case from that angle, this will not be my domain to argue because I cannot be privy to the decision-making process of the government. Because I am a government employee and I have diligently followed the orders.
You tell us why you are interested there, why you have been brought there.
Well, I don't have any interest.
Why the
I am a man from.
No, why does the minister has to pick up
Well, that
you?
Well, that I really don't know because I am a man from East Coming district.
No, you must
And
know.
actually,
You must know. You are happy to be there, you want to go there. Did you approach him?
no, I did not. At least in file noting.
Is there anything against him,
No.
petitioner?
No, nothing because it is purely on the administrative exigencies. My lord will kindly have fundamental.
It doesn't support.
Well, then my lord will.
Your record doesn't, the record of the government doesn't support. That is, it is on administrative exigencies. Just issuing a transfer order on the request of the minister,
Therefore, my lord.
describing the public interest or administrative exigency will not do.
No. Therefore,
There should be something more than
yes.
there in your file.
Something more is, my lord. The answer is available at Fundamental Rule 11. Kindly please.
It's a discretion,
Yes.
unfettered.
No.
You have access, they have access discretion.
Decision-making process. my lord.
Free play which has been given to you have been mortgaged. The discretion which you have been given,
Well,
authorized and empowered,
I
has
bow
been
down.
mortgaged.
I bow down, my lord. Kindly appreciate from this angle also. From the service jurisprudence point of view, my lord. Kindly come to Fundamental Rule 11.
No, it's okay, I've seen it.
So, employer has a discretion over.
No,
the
what he's
employee.
saying that he's not asking for a particular place. What he's saying is, I've been frequently transferred after every 1 year. Now, finally, on the basis of your note,
My lord, the
without
answer,
there being any administrative exigencies or public interest,
my lord, the answer lies at paragraph
I
8.
would have been allowed to continue his normal tenure, which is a professional norm.
Correct, my lord. That nobody can dispute. The answer is.
You allow him 6 months. No. You allow him 6 months and you take a call. Will he interfere the transfer order? Since he is still working, when did you file this red petition?
My lord,
It's been how many months?
not more than. On my lord, 27th September. 27th September.
Hmm?
No, my lord, he has enjoyed more than the required time. Let me also have the taste of that office.
No, you come back after 6 months. You be there after 6 months
I'll
and
come,
complete another 2 years.
I'll come back after 2 months. Kindly accommodate me. After 2 months, my lord. In any case, my lord, he has taken the shelter of the guidelines. So Govardhan Lal judgment is very clear, my lord, 2004. If he's taking shelter, it goes adverse to him kindly for the moment, my lord, that guidelines. No,
I thought of
no, my lord, he is from
dictating in the open court, since you have relied in so many cases, the learned counsels.
my lord, for a moment, kindly,
So
for a moment, my lord, kindly come to this.
hearing concluded,
My lord will note that on page 20.
I've seen it, I've
That
read it.
Number one,
Twice I have read it.
yeah, number one, my lord, because that this equally applies to him. In fact, I'm from East Kami, he is from Lower Subansiri only. Then my lord will quote that fundamental rule 11 and 14. Grateful, my lord. Obliged.
Third, Mr. K. Perry, learned counsel for the case. Mr. B. Pitcher, learned counsel, learned standing counsel for all the respondents, state respondents.
Respondent 1, 2.
1 and 2. And you are for respondent number 3.
3, my lord.
3. That's all.
That's all. Great, sir. Obliged.
Measurement.
Hello, sir.
What is this, sir?
Well, this poor fellow has retired. He has been deprived of all the consequential benefits and then not acting
Have
upon.
you filed?
No, my lord, I'm playing some time, my lord. I'm preparing for lesson
My
2
lord,
and 4.
the-
You have retired. Now you are asking for the promotion.
Yes, ma'am. There is one judgment on the same department, on the same issue.
Let me see. Let me see. After retirement,
After retirement. Luckily, the council was me only. And opposite side, my brother Parme was there.
it's a covered case.
No, my lord.
No, same.
If it's covered case, we'll dispose it.
My seniors, my lord. You have not gone through this in any party case. Brother Parme was also there for the department. He is aware we argued this matter. I think Riram was also there in this case. No, Wangmo was there.
What is the reason that you should be considered from the date of your officiating or
My juniors,
My lord,
that they
what?
did not conduct a DPC in time. Then my juniors were allowed. They were given full pay scale protections. In spite of several representations, they are not acting upon. And in this case, my lord, the final conclusion is going to happen. The direction in this case, actually same only, my lord.
The time, my lord, our epidemic will be required, my lord. What he is contending, my lord, when he was given officiating appointment, there was a post, he was eligible, my lord. Now, to whether that pleaded peg is true or not, my lord, we need to file affidavit, my lord.
Let them file a detailed affidavit. But affidavit of chief secretary is required. Where is the chairman?
Yeah, there was some general director were promoted from the with retrospective effect, but the petitioner was not promoted.
Correct.
From the date of DPC.
Well,
But here is you are seeking for promotion.
Only now, my lord, since I am retired, then what happened, my lord, that
No, you didn't. Your promotion was not affected during the your
it was affected, my lord.
service
It was affected.
as a joint director.
Yes, a joint.
Show me. Joint director.
Yes.
You are allowed to officiate. Continue to officiate. Show me that DPC.
Page 41.
Page 41. Recommendation.
Yes, and that the DPC was informed that post of agronomist deputy have fallen vacant due to promotion of Nini Patil, the petitioner in that case. Post joint director with effect from 24/7/2012. However, DPC for the post of agronomist deputy was not held at that time. Had it been held at that point of time, I would have got the benefit. Tadu Game, I am
No, you are Tadu Game, na?
yeah, director marketing working
Business
arrangement,
director,
being
marketing
senior most in the Peter grade. I am the senior most.
No,
They're
no.
promoted in the working on ITNA in 2012. Kindly see what they have done in this case. DPC was further applied with Tadu Game Agro Deputy was later appointed to the post of joint
Where
director.
is your DPC has not recommended you for joint director?
No, that's why, Milord. They have given me, they have regularized me.
Sir, there is a difference. In this petition,
Correct.
your substantive post was deputy director. And you are allowed to officiate and then retire, isn't it? So you are seeking that I should have been promoted as a joint director from the date of officiating. Then you become eligible for, you are allowed to hold the in charge director also.
No, I was told I was.
No,
allowed to
you are
retire,
till
but-
retirement, you are deputy director. Here is a case where your juniors or your friends, colleague, who were promoted,
It's the same thing.
their promotion with effect with
Yeah.
retrospective effect.
My lord,
But this petitioner's promotion was from the date of DPC. This is the difference. Anyway,
anyway, my lord, that even in page
it's not
39,
same. Distinguishable.
I'll put up across different because that RK City versus ONG.
And most important difference is here's a petitioner who has been promoted in the post of joint director with effect from the DPC. This present petition, he has not been promoted because he could not have been promoted because he
And
was
then
only
here-
allowed to officiate.
Yes.
No question of retrospective.
No, that my juniors were given promotion. That is.
I don't
ever-
know by reading
No, no,
this,
no,
this
it is-
judgment.
No, this is correct, no. This is ever.
This may be correct, but it's not the
But-
same.
It is ever in my read petition. Let them file affidavit.
No, it's not the same. Anyway, you clarify that by filing affidavit. Heard Mr. P.T. Tara, London Consultant. Mr. I.D. Rampur, respond number 3. 1. Mr. L. Perme for
2 and 4, my lord.
London Council, the London Standing Council submits, he may be granted 3 weeks time to file counter affidavit. That is allowed, list after 3 weeks. Maybe interesting.
Yes, my lord, I have few other authorities.
Lordship, on the earlier occasion, the case was on the instruction, not the submission. In this case, as per
Your instruction,
the instruction, he has already joined and working there
where?
at Boleng.
Boleng.
Yes, his salary of monthly salary of was released from Boleng already, and he is working there. Right. And the private respondent has been transferred to Pasigat, but he refused to join This is the case. And ground for not joining is, one is as per the earlier submission on the, it was, one is, his wife is working at Pangin as a nurse. And another is, another is, he's seriously ill. He wanted to get check up. And in that case, I would like to express my opinion that in case of this health issues, over his health issues, Pasighat is the better place for health sector. And another is that the joint transfer, joint transfer was seeking. And for joint transfer, as per rule, the agreed party has to approach the competent authority saying that my husband has been transferred to Pasighat, and I may be allowed to go together at Pasighat. That is the appropriate procedure. And both the ground, it is
But
placed by
other
the
way around, if he wants to remain there at Pangin
Yes,
or Boleng,
Boleng.
she is already there.
I'm
Other way around, the respondent is asking that since my wife is there,
yes,
Pangin,
yes.
since my posting is it's
Actually,
akin to joint
this
posting, so I
Private
should be allowed
respondent
to be
is
there,
posted
remain
at
there.
Boleng, and his wife is at Pangin.
What is Boleng and?
That is 16 kilometer. 16 kilometer.
I don't know. This court doesn't know. Huh?
And that is why I am to say that is not a valid ground for consideration. Not a valid ground for consideration. Of
Not,
this
not any
personal-
counsel. We want that your colleague, your client.
Because it will disturb. Election is also approaching. It is
You are
admitted.
from.
Election.
You are from.
I am from Pasighat. He is from GXC within this Pangin Boleng.
He will again be
Okay.
posted out, my lord, when the election model code of conduct comes.
There is.
Again, you will be posted.
It will disturb my this working on public interest. I have been posted there and working there. And again, if he is returned back again, I have to within
Who
the
is
same
working there?
step.
Who is working there?
I'm working there.
No, this is.
I'm working there.
Madam,
I
this
have
is incorrect. It
kindly
has been
kindly
and
see the expenditures and this record. This
Is there is there
office note, office
is
note.
there interim order?
there
Yes,
is an
interim order is
interim order.
in
as
my
well as-
in my favor.
There is an interim stay order. By
In my
order
favor.
dated 30 November 2023, the petitioner was released from there when he joined, pursuant to that person modification order. So technically, madam, I was working, and although he might have assumed the expenditure, but in view of this release order, he is no more working there. Madam, for 1 month, madam, that was taken on record as produced by the standing council other day.
Kindly see that this office note page number 41. Director has expressed his mind.
This is 13 November.
Yes, he was released actually.
No, but then interim order is there,
Yeah, thereafter.
and all the subsequent actions pursuant thereto.
Yes, has been stayed.
Transfers order dated 17/11 and 7/11 and the subsequent actions.
Yes. So that,
Will be contained.
no, this was taken on record, madam, when on the day
No, that's what I'm saying.
it was produced.
After this only,
No,
this court has passed the interim order.
yeah, after this only.
So it has no bearing now.
No bearing now. Meaning,
You are not complying, maybe different, it's a different thing altogether.
no, madam,
So you are working,
Yes.
you said you are also working.
I am also working.
Both you will be there, this after 6 weeks.
All right.
Huh?
Madam, only for 1 month. Accommodate.
He's not agreeing.
That will again hamper my this.
Hmm?
I have to work for the department on public interest. It is the. I've been already working.
No,
as
that's
per
why
the-
basically this, since you are colleagues and he's a diabetes patient and considering that his wife is at Boleng, so
Your
we thought, why
Lordship,
this transfer, well should
Lordship,
fight on the transfer?
one
You
issue is one issue is the
be serious to your profession, why after the transfer?
The issue is,
If you don't get salary,
issue said that it will create more this difficulties.
Since I have not been released, so whether that, let it be after 6 months.
Because kindly see this.
Well, 6 weeks will suffice my work because I can have the support of my wife.
It will hamper that this working.
no, he is seeking for adjournment. So that within these 6 months, he can urge the authorities, request the
He
authorities.
can file
for
separate writ petition.
joint
He can
posting.
file separate writ petition as well as he can file representation before the competent authority for consideration of his prayers. Whether
Heard Mr. T. London Council for the petition. Also heard Mr. Which for respondent number 1? You. Respondent K. Wong for respondent London State Council for respondent number 1. And El Perme for all the other 2, 3, 4, 5.
2 and 4, my lord.
2 and 4. You are for? Number? Mr. T. T. Tara for
Sorry.
writ petition is admitted for hearing. List after 3 weeks.
stay already till suspended.
Interim order earliest, first earliest shall continue.
My lord, this matter may be, I may be allowed to withdraw this matter with the liberty to file afresh.
Mr. T. Omo, learned counsel for the petitioner submits that he may be allowed to withdraw this writ petition with the liberty to file afresh. Praise the Lord. The writ petition stands closed on withdrawal with a liberty as before.
Was
You just mark their presence. You are for respondent number?
1 to 5, my lord.
1 to 5. You are? Private respondent number so and so, huh?
applies.
My lord, this contempt case,
Yes.
since earlier respondent, chairman is already transferred, now I want to take instruction from the present incumbent, whether they are taking any steps. So earlier appeal also was pending, and earlier there was a stay order, but it was not extended due to something. Advocate, presenting advocate could not, did not seek for extension. So stay order was vacated. So let me take instruction from the present chairman.
Objection.
One point I will comment. Order was passed in the contesting case
Yes.
in presence of both the parties. It was submitted 2 months time was given by the honorable court. And contempt starts just after 2 months. Stay was granted thereafter. For the interim,
What stay was granted?
stay was granted, the order was stayed in appeal before this court in a division bench. But the stay was for a conditional stay. It expired.
Okay, which we have heard.
Yes.
Sitting division bench.
Yes. But
It's okay, order come, let it take instruction. What is there, what is
all
not
right,
there.
instruction.
Heard Mr. So-and-so. G
board.
board.
May
And it
may-
is for the-
may we get
No,
same date?
then Mr. For petitioner. And Mr. G Tarak for respondent.
For respondent.
Alice contender. Mr. G Tarak, then council submits that he may be granted 3 weeks time to obtain instruction.
Maybe take
Praise
the
the
same
Lord.
date, 20th of December.
List after 3 weeks.
20th of December, maybe. 20th December.
20, 20.
So it will be.
20/12/2023.
Obviously.
Your Lordship, I have filed this IA praying for the implement as a party to the case. And the reason I'm trying to implement is that in the tender process which they have put challenge, I'm the successful bidder. So my presence in this case is essential. Because any other part in this case will affect me directly.
Have you served the copy
Yes,
to
yes, yes.
what he said? Any
He says-
objection? No objection.
He had no objection.
You are for respondent, petitioner. You are for petitioner. Ah. Heard Mr.
Ketaja.
Keta, learned counsel for the applicant. By next, and heard Mr. And also heard Mr. G. Tarak for no, Mr. So and so for writ petition opposite party. Correct? And Mr. G. Tarak for standing counsel for all the state respondents. Standing counsel are they will be appearing for all this. By filing this application, the applicant press for implement in the connected writ petition with WPC 546 of 2023 within the measures MS Semco Construction so and so. On the ground that the petitioner has challenged the rejection of his bid by the respondent authority pursuant to the tender dated, which tender dated pursuant to the NIT dated 28/9/2023. The learned counsel for the petition was submitted. Is one of the
Successful bidder.
successful bidder in the tender process being NIT dated 28/9/2023. Therefore, no, therefore. Any order passed in the connected writ petition will affect the applicant. Therefore, he being the necessary party, be allowed to participate, be allowed to implement and participate in the writ proceedings. They are not being opposed by the learned counsel writ petition as well as the learned standing counsel for the state respondents. Next paragraph. Having considered the submissions made by the learned counsel for the applicant, and they are not being objected to by the learned counsel for the respondents, the writ petitioner and respondent. I deem it appropriate to allow the applicant to be implemented as respondent. What respondent?
It will be 5.
Respondent number?
I be the respondent number 5. 4.
Respondent number 5 in the writ.
Or 6, you'll see.
Respondent number 6 in the writ petition 546 of 2023. Accordingly, this IA stands allowed and disposed.
No. Thank you, Lordship. Oblige.
May I please, my lord? My lord, this is an application for implement
for respondent number 3 and 4, as the earlier, this respondents alleged contemners were transferred out. And the new incumbent has been posted in their designation.
You are for?
For respondent number 1 and 2.
Who has been transferred? Who has been transferred out?
Erstwhile,
Respondent number 1.
respondent number 1 and 2, both,
Now they are new incumbents.
they are new incumbents. Erstwhile,
Mr.
by name was,
SK Jamal, Learned Counsel for the. Any objection? No.
No objection.
Learned Counsel for the applicant. Public petitioner. You are a petitioner, right? Right?
yes.
Also have
Applicant.
Mr. So and so for respondent number 1 and 2. At least contender number 1 and 2. They will remain. These two persons will also remain.
Yes.
Who are they?
They were erstwhile DC Upper
No,
Subansiri
what is
district,
the name of that?
Mikar Nyori APCS and Sri Manik Bui APCS.
Now,
Now the new implemented parties are Sri Penga Tato, the incumbent
I think this
present
is
DC,
case-
as well as Sri Otam Jammo ADC.
the petitioner prays for implement of Sri Pengatata, Deputy Commissioner, Upper Subansiri District, and Sri
Otam Jammo, additional.
Additional Deputy Commissioner. Good for you. Upper Subansiri District. On the ground that the earlier incumbents have been transferred and the above named two two persons are the present incumbent for which they may be included in this contempt proceedings. Next, having considered the submissions. This court deem it appropriate to allow this application by including Sri Pengatata, Deputy Commissioner, Upper Subansiri District, and Sri Otam Jammu, Additional Deputy Commissioner, Upper Subansiri District, as respondents number 3 and 4, huh?
Yes, my lord.
3 and 4. Accordingly, the application extends along and discuss. Accordingly, accordingly, Sri so and so, about this name be implemented as respondent 4 and 5.
3 and 4, my lord.
The I extends allowed in disposal.
Highly obliged.
Much obliged.
Who is for respondent number 2 and 3? 2 and 3. Why you are not filed the counter affidavit?
We have some priority reply from the department.
Huh?
They have not replied. We have some priority reply from the department.
Heard MS
Reading me.
so and so learned counsel for the petitioner. K Wangmo for 1.
Yes, Manoj.
And have you filed the?
Yes,
And Mr. So and so for response 2 and 3. Office note dated 21/11/23 reflects that service report in respect of respondent number 4 is still awaited. K Wangma, the state council submits that she has already filed out which affidavit in opposition. And Mr. So and so for respond, learned counsel for respondent number 2 and 3. Press for and granted 3 weeks time to file counter affidavit. List after 3 weeks.
I beg your pardon, mine. But on the item number 18, and as they are newly implemented, and I was just.
Okay.
So fresh steps for on respondent number 3 and 4.
Learned counsel. The steps be taken for service of notice upon respondent number so and so, within 2 weeks, 2 days.
Yes. Highly obliged.
List after 3 weeks.
Much obliged.
I also forgot.
May my lordship, only yesterday they have served us extra copy, so we need some more time.
Mr. So-and-so for petitioner, learned counsel for petitioner. MS K. Learned counsel for the learned state council submits that she has received the extra copies yesterday only, therefore, for which she seeks 3 weeks time to file affidavit. Affidavit in opposition. Praise the Lord. List after 3 weeks. Mr. So-and-so for respondent number, Mr. Upon respondent number 3 is still available. List after.
Yes. Yeah, my lord, interim is there, let me.
Interim order passed earlier, so continue. What's to be done today?
Your Honor, I am in this matter, I'm representing private respondent number 2 and 3. Since the main affidavit in opposition is to be filed by the APIC.
Which 2 and 3? You are for 2 and 3?
Yes, 2 and 3.
So you don't want to file affidavit?
Your Honor, I will file my counter after the affidavit filed by the respondent number 1.
Don't make a submission to that. There's a reason why I'm saying.
Lordship,
Are you getting it?
Yes.
Don't make such a submission.
Pardon, Lordship.
Be careful next time.
So I may be, since they might take some more time, so I may also be allowed to.
Just say submit your part,
Yes,
not for others. All right?
Yes.
Hard. Not hard. MSO and so appears for petitioner.
Yes, your lordship.
Your name, please.
Adem Tang, your lordship.
Non appears for respondent number 1 on call. Non appears for respondent number 1. Mr. T. Omo,
Yes.
learned counsel for
Two and-
respondent number 2 and 3. Press for and is granted 3 weeks time to file.
Your lordship,
affidavit in opposition.
interim may be continue, your lordship.
Interim.
Yes, your lordship.
Interim order was earlier shall continue.
Most obliged.
I do oblige your lordship.
Huh? You will finish the orders. You want time?
Yes, my lord. My lord, government has to be
Affidavit, sir.
filed affidavit.
What about affidavit?
No, Your Worship, we have not received till date. The department has sought some.
By so and so learned counsel appears for petitioner. Mr. Y. Ridham, learned state council submits that is respondent granted, is granted 3 weeks time to file affidavit in opposition. Yes,
Right.
after 3 weeks.
Your lordship, state respondent yet to file their counter appeal.
Your lordship, we have not received the instruction, so your lordship, some more time may be needed.
And Mr. I. Bam for learned counsel for petitioner, Mr. MS, you are for respondent number?
Respondent number 2, your lordship.
You are one.
Yes, sir.
Next,
But
we
we
come
compare
to for
here.
respondent number 1, standing counsel appearing for respondent, MSP Pang Learned Council, State Council. Press for and is granted 3 weeks time to file affidavit in opposition.
There also.
Mobilize, your lordship.
Post this, there's a, PP of AP also, but this is a compensation method. So in here, we are not a necessary part.
It's okay.
It's like, it's
Next.
Mobilize, your lordship.
Highly obliged.
This morning only I have been engaged by respondent number 7 to 10.
7 to 10.
If it is clear,
7 to 10.
7 to 10.
7 to 9 or
9. 7 to 9.
private respondent? will be
10 or
7 to-
9.
7 to 9.
You have been engaged without discussing the matter.
Oh, 7 to
7 to
10.
10.
Okay, okay.
7 to 10.
Yes. My lord, I will find my work within a week.
Had Mr. Odu Learned Council for the petitioner. You are, who is respondent number 1?
1, 5, and 6.
1, 5, and 6. MS T. Wangmo, Learned State Council for respondent number 1, 2,
1, 5, and 6.
1, 5, and 6. Mr. D. Kamduk for
2, 3, and 4.
2, 3, and 4. Mr. Next pair, Mr. So-and-so, Learned Council for the Learned Council submits that he has an instruction to appear on behalf of respondent number 7 to 10.
10.
Why office not said 9? And 6 for which he seeks for 3 weeks time to file counter affidavit. Read along. List after 3 weeks.
My lord, I
Yes.
beg to adjourn this matter, my lord.
Why?
My lord,
No
my
adjournment.
no, my lord.
2017 matter.
Yes, my lord, my senior leading counsel M14 due to health.
Tomorrow.
No, my lord, due to health issue, he's organizing local ritual at his hometown, my lord.
Okay.
After a week, my lord.
2017.
Yes, my lord.
As a last chance.
Yes.
Mr. So-and-so, Learned Council appearing for Mr. M. Pertin, Learned Senior Counsel for petitioner. Submits that his senior, Mr. M. Pertin, is performing a local
Yes, local ritual, my lord.
local rituals in view of his health. Due to his health problem. And press for listing the matter after
Week, my lord.
a week. After 2 weeks.
Yes, my
Praise allowed. List after 2 weeks as a last chance.
Much obliged, man.
No further adjournment shall be granted.
My lord, I will pray that this matter may be disposed of today. It is
Why?
pending since, it is pending since 2019.
Lordship,
And the matter is very simple.
in this matter, your
today.
lordship had a discussion with
We'll see
Gautam, madam, your
at
lordship.
2 o'clock we'll see. I think there's some doubt.
And
I may
you-
not be able to take up.
Yes, your lordship.
We'll see at 2.
Oblige.
You find out, they are saying that I cannot take up this matter.
My lord,
But I remember I discussed with all these issues.
then in that case, lordship may kindly agenda matter.
Yes, your lordship.
Because it's not one matter. We have discussed, I've been,
But my prayer would be that.
I was
lordship-
consulted for entire state
Yes.
in this regard.
The-
Then in that case, list the matter before any other appropriate bench. without-
Next week,
without me.
if that is available.
Huh?
Next appropriate bench is available next week, then it may be listed.
Appropriate bench. It may come up tomorrow also.